Good afternoon, members of the Fourth Estate. As you are aware, on the 13th of February 2025, Ferdinand Waititu was able to be convicted under the Anti-Corruption and Economic Crimes Act, and pursuing his right of appeal, which is the ordinary course of justice, he has instructed us to pursue the appeal on his behalf, and we have done so by raising very many grounds of appeal, amongst them being that the trial court and the trial magistrate did not take into account a wide array of evidence brought into his defense, but in the event, or rather, but went on to consider the prosecution's evidence only. As time will show, and the appeal will show in due course, that we are keen on securing a safe and practicable solution, which is justice to Ferdinand NDUNG'U Waititu. So we have also been able to file an application for bail pending appeal, and as you are aware that the high courts have been so grateful and have been instrumental in ensuring the right to liberty despite a conviction being passed by a trial court. Therefore, we have moved the court under the same provisions, asking and demonstrating to the court that Ferdinand NDUNG'U Waititu, as he is, being a convict, has the right to liberty, which the Constitution of Kenya secures and guarantees every right, or rather guarantees every person of that right. And I wish to also say that being a convict by a trial court does not in any way mean that you are guilty until all the avenues of appeal are exhausted. Thank you.
The state. My brother Stanley Kiambu has quite summarized the events of the 13th day of February 2025. Now, over the weekend and from when the court rendered its decision, we've had an opportunity of going through the entire judgment, the 212 pages judgment, and the conviction as rendered by the trial court on the 13th day of February 2025. And there are a number of issues that have come to light, which have given us the encouragement that indeed there is the wisdom in having the number of courts up above the subordinate courts, so that the High Court can have an opportunity of going through the record again and appreciating that indeed there are a number of mistakes that have been committed. In our memorandum of appeal dated the 14th day of February 2025, we have come up with numerous grounds of appeal to suggest that indeed there is an arguable case that we can make at the appellate stage, so that we can have the judgment, or rather the decision to convict and sentence Honorable Ferdinand NDUNG'U Waititu, alias Babayao, set aside or disturbed for that matter. Over and above that, there are numerous exceptional circumstances that will ordinarily warrant the release of Ferdinand Babayao Waititu on cash bail or bond pending the hearing and determination of the appeal that we have filed. As you are well aware, on 14th day of February, when you are celebrating your Valentine's Day, Babayao was taken ill at the Kenyatta National Hospital, and he's since been recommended some medicines so that he can tone down some of these challenges have now. So we are hoping that for us to save a life, for us to avoid a situation that befell one Kakuyo in the later days when he was convicted and later on you know, when they filed an application for bail pending appeal, upon his denial, he died while he was in police custody. So we are hoping that the court, at the very least, will first make a declaration of the appeal that we have filed, so that in the fullness of time, we are going to persuade the court that indeed there are errors that were made by the trial court that will disturb or lead to the disturbing of the finding of the conviction and the sentence that was handed down to Ferdinand Waititu, Baba Yao. Thank you.
It's at, and I wish to say this. In the trial before the subordinate court, Baba Yao was being represented by a different team of lawyers up till the conviction was obtained. It is only after the conviction that we were instructed to come on board to see to it that we analyze, sift through the evidence that was tendered before the subordinate court for us to come up with grounds and see if those grounds merit an appeal. Now, we have since perused the proceedings and judgment of the court, including the sentence, and we have come up with one singular decision and opinion that this is a case that merits an appeal, which appeal has already been filed. And alongside that appeal, we have also equally filed an application for bond. What that means is that now, several grounds have been raised. Without going into the merits of what has been raised in those grounds, we feel that it is important that the country knows that Baba Yao has been convicted from our standpoint. Now, speaking of the any convict to ventilate an appeal, and as that appeal is being presented and being heard, the law provides under Section 357, which have moved, that is the Criminal Procedure Code, that that party can be granted terms. Now, remember, there is a presumption of innocence in our laws, but Baba Yao has since been convicted. It means, therefore, that the threshold of that proof beyond reasonable doubt has been exhibited by the prosecution, but we are going to overturn that in the appeal because of the grounds that now we have raised. What presents therefore is that in the fullness of time, when the appeal is going to be processed, we shall be able to analyze clause by clause of that judgment to pick those points or pointers that the trial magistrate erred in law, and even in fact, because from a lay point of view, is that there are several anomalies that befell the analysis and the evidence that was tendered in by the trial magistrate, and that is why we are before the appellate court. Now, it is important also to know that the appeal mechanisms in this country are well choreographed in the Constitution and also in the statute books, because once somebody has been convicted, he has that right to appeal, and that is why the court normally gives 14 days of right of appeal, and that is why we have filed this appeal within time. We could not wait for the lapse of the 14 days. We have the proceedings, we have the judgment, we have the sentence, so that is why we moved to the High Court. And in the event, in the unlikely event that it fails, then there is also the Court of Appeal that also will analyze. Now, the Court of Appeal is only going to analyze on points of law only. In the High Court, we are going to ventilate issues of law and fact, that there was this contract, there was this other thing that was presented, and there was an oversight by the magistrate and overlooked some of the issues that were supposed to have been merited. Because any iota of doubt that has been raised, any iota of doubt that was raised in that judgment, in the proceedings, it ought to have gone to the benefit of Baba Yao, and Baba Yao actually ought not to be in prison, but out here, trying his life and doing things that a normal, ordinary citizen does. So we bring this to speed to the Kenyans that we are here, we are going to ventilate it, and in the fullness of time, things will be crystallized, and he shall come out, God willing, and enabled with the law. Thank you so much.
Put the mother of all battles to save his life. Two issues come up. We have gone to get him out purely on two grounds before the appeal is done. One, on medical grounds. This is a man who is above 62 years old, suffering from chronic fatalistic diseases. We have provided evidence from Kenyatta National Hospital and the prison medical facilities. We are seeking that he be released to attend to his medical conditions as he is outside. Number two, we are also looking at the judicial sentencing policy. At 62, with such medical conditions, can the facilities called prison be able to keep this man alive for him to see justice be done to him? Third, this appeal raises over 57 grounds to ensure that Baba Yao is free to continue politics as this matter proceeds. Remember, Baba Yao is a politician. Baba Yao is a citizen of this country. Baba Yao is protected by the constitutional provision of this country. This is not the first time the High Court and the Court of Appeal has released people who have been convicted by the ethics anti-corruption courts. So we are relying, for example, on the Waluke matter. For example, this was the team that was part of the Waluke defense team, and we hope that we will be seeing Baba Yao coming out very fast so that he can continue with his life. Lastly, a notion was created that Baba Yao was admitted or he went to hide in hospital at Kenyatta National Hospital. The facts of the matter is that when we were in court, Baba Yao was unwell. We informed the court gave directions for Baba Yao to be taken to hospital. We were called as his team, defense team. We went with Baba Yao to Kenyatta National Hospital. The doctors wanted to detain him, but we advised that if he can be stabilized, so that there is nothing called preferential treatment for Baba Yao. He is a legislator, he's a politician, he's a citizen, former governor. Let him go and sleep in prison like anybody. As we are talking like this, Baba Yao is undergoing medical treatment at Industrial Area Prison. He's not at Kenyatta National Hospital. We hope the court will be moved with the facts that we have given to be able to give us a date to argue the application for bail, and we hope, because this is a special wing of the High Court, the Anti-Corruption Division, we hope that by next week or this week we shall be arguing for the release of Baba Yao. Kwa wale ambao ni